Good afternoon or good morning if you're on the West Coast or in Alaska, and thank you for joining us for Implementing a Service Contract Act Compliant Paid Leave Policy. My name is Nichole Atallah. I'm a partner in the Labor and Employment Practice Group here at PilieroMazza. We are a full-service law firm located here in Washington, D.C. We specialize in matters relating to government contractors, although our labor and employment practice is a full-service labor and employment practice group, and we cover anything from EO matters to, as we'll talk about today, the Service Contract Act, equitable adjustments, you name it, we can probably help you, or we have a referral for you if we can't help you. And I'm here with my colleague, Meghan Leemon. She's an associate in our Colorado office, and I'll let Meghan say hi.
Hello, thanks, Nichole. As Nichole said, my name is Meghan Leemon, and I'm an attorney with PilieroMazza. I am based out of our Colorado office, so we're actually not in the same room as each other. So if there's any kind of hesitation, that's why. I practice predominantly in our government contract group, but I also work with Nichole on employment matters, particularly EOC compliance and Service Contract Act matters.
Thanks, Meghan.
Thank you for joining us.
Great. Well, I'm happy, and like Meghan said, we are in 2 different locations, so we're trying this out, but I think this will go off without a hitch, and we're very excited. As all lawyers do, I have a disclaimer for you, and it basically says that we're here for informational purposes. We are not providing specific legal advice just because of the way things change, and we don't know the facts of your specific situation. So if you have a specific situation that you want to talk to us about, please just reach out. I'm happy to talk to you via phone or email. You have both Meghan and I's contact information, and we are happy to help you with any specific situations that you have. If you have any questions today, please enter them in the question section of GoToWebinar, and we will try to get to them as we go through the webinar today. If for some reason I don't get to them, or they're very, very specific, I will get back to you, or Meghan will get back to you after the webinar today. The slides will be sent out after the webinar closes, along with a recording. So if you have a colleague or friend that wasn't able to attend live today, please let them know. I already talked about us, so I'm going to cruise through this, but I do want you to know that we have a ton of information up on our website. We have newsletters, blogs, recordings of past webinars. Please take advantage of all of the extras that we offer to our clients, and even if you're not a client. So why are we here today? We are here today to talk about the SCA a little bit. We're not going to do a full SCA training today. That takes me at least a couple of hours, if not a couple of days. But we are going to touch on SCA benefits and leave. And we're going to talk about how the vacation leave works under the SCA, and how state and local sick leave laws or family leave laws tend to interact with the SCA and those H&W or vacation leave requirements. We're also going to talk about the Executive Order 13706, paid leave for federal contractors, and then build on how that works within the SCA framework, because this is getting very, very challenging to figure out how all these puzzle pieces fit together. And then at the end, I'm going to talk a little bit about compliance strategies. And the reason why we thought, why would you spend an hour on paid leave? Well, it's a question I get every single week, so I wanted to share that with you. To start, I'm going to launch a polling question here. I just opened it, but basically I want to get a sense from you all what kind of leave policies you currently have in your firms or in your agencies. So do you have a combined pay leave policy for all of your employees? Do you have separate leave and vacation allocation, so a bucket of vacation, a bucket of sick? Or do you have different pockets, different classes of employees that your company treats differently? I'll just give you a second to finish this poll. We still have some people. We're almost at 73%, so it's great. Right now it's a looking a little even. So it's 78% voted. Let me see if I can get a little bit more than 80% here. Let's go ahead and close it. It looks like 38 or so percent say that there's a combined leave policy, paid leave, so you combine it all into one bucket. About 18% of you say you have separate vacation and sick allocations, and about 38% of you say it depends. It depends on whether you're an SCA employee, it depends on whether you're under a collective bargaining agreement, or if you're in our executive staff, that kind of thing. And a few of you don't know, and that's fine, then that's fine too. But it seems like in the last couple of years, the pendulum has really was swinging toward a complete combined paid leave policy. And as you'll see today, as we walk through the Service Contract Act and we walked through these leave policies, you know, some companies are beginning to consider whether from a strategic perspective it makes sense to have separate policies again. So again, a lot of this is strategy. So as we walk through today, we're going to be thinking about what strategic decisions you might and questions you might want to ask yourselves as you're making these decisions going forward. So let's talk a little bit about the Service Contract Act. What is it? First of all, I think that's just an important basic thing we need to know. It's a prevailing wage law for government contractors where the contracting officer has made the determination that there is a contract principally for services performed in the United States and performed through the use of service employees. And what does it mean to be principally services? Generally, it means that most of those working on the contract are non-exempt hourly folks doing things like janitorial work, maybe some healthcare services, food services, and maybe some maintenance services, that kind of thing. So those are the types of employees we're generally talking about, although we do have a fair number of administrative folks that are covered by this as well. So what is a service employee? It's basically anyone, once the SCA is put into the contract, and the FAR clause is 52222-4(1) through 4(3), if you're curious about the FAR clause. A service employee is going to be anybody who works on that contract once the CO puts the right clauses in your contract and puts a wage determination in your contract. With a fair number of exceptions, and those are exempt bona fide executive, administrative, or professional employees under the Fair Labor Standards Act. So those are going to be those people that are paid on a salary basis. And that's, you know, that's a whole ball of wax in and of itself. I was just telling a colleague this morning that there is a new startup that got hit with about a $4 million judgment at the Department of Labor because they misclassified exempt employees. And we have a full webinar that's an hour and a half to 2 hours just on the Fair Labor Standards Act. So if you're worried that you haven't classified folks correctly, this is going to be critical not only from a general FLSA overtime compliance, but to be compliant with the Service Contract Act. You need to make sure you have a really good handle on who those exempt folks are and whether they can be exempt from the provisions of the Service Contract Act. The other thing that surprises people is the contractual relationship does not matter. So it can be an independent contractor, for example, that if they're doing the same thing as some of those service employees do, they would be covered by the Service Contract Act. And so then we ask ourselves, well, how do we keep ourselves at a distance from those independent contractors, as we have to do in order to keep them independent contractors, but still pay the wages and fringe benefits required by the Service Contract Act. And the good news is that a lot of these benefits can be paid out in cash, but if you're looking for strategies there, just please give us a call. So what are the contractor responsibilities under the Service Contract Act? First of all, you got to look at your wage determination. This should be in your contract. And these are, it's, you know, a couple pages usually attached to the very end of a contract. It's got a wage determination number, and it has a list of all of these classifications. It has the minimum wage rates to be applied to each of those classifications, as well as a health and welfare rate. Currently that rate is $4.27, but it depends on what's in your contract. This is a creature of contract. So if a contracting officer put an old wage determination in your contract that has, say, a $3.81 health and welfare rate or a $4.02 health and welfare rate, you would apply what's in your contract, not necessarily what the latest and greatest wage determination is from the Department of Labor. It's a creature of contract. So you've got to classify employees in the right classification, and you can do that by looking at DOL's Directory of Occupations. And then you've got to pay the right benefits. So you've got to pay health and welfare, vacation, and holidays. And we do have a question that came in about exempt employees. Is an exempt employee still covered under the SCA? No, not generally. Those are exemptions. So if you have exempt employees that are paid on a salary basis and properly classified, they do not get the SCA wages and fringe benefits, okay? So again, it's really important to know if you've classified them correctly, because that's a huge area of liability. But if you have, they are not subject to the SCA requirements. You can pay them in accordance with the General Fair Labor Standards Act requirements, so on a salary basis in excess of $455 a week, and they have to meet those job duties tests. But again, give me a call if you have any questions about that. You also must flow, if you're a prime contractor, you have to flow all of those requirements down to subcontractors, including the appropriate wage determinations and FAR clauses. So let's jump into the benefit section, because that's really what we're going to focus on today. And let's talk about health and welfare benefits. So these health and welfare benefits are listed on the wage determination. It's that amount that I just referenced on the last slide. So currently, if you have a contract that was recently issued, you're probably going to see $4.27 for every hour worked up to 40 in a work week. That's the typical nomenclature. But you'll want to really focus on what is in that wage determination, because there are differences. There are different types of wage determinations that are issued. You might have a collective bargaining agreement instead of a regular wage determination. You might have what I call the old wage determinations, or the even-numbered wage determinations, that calculate health and welfare a little bit differently. I'm not going to go into that too much today because it'll eat up so much of our time, but you should know that if you just read that wage determination, it will kind of give you some of the rules of the road as far as whether you have to pay it on an hourly basis to each employee, up to 40 hours paid each work week. That's the most common wage determination that we see. You can provide these benefits in any type of bona fide benefit that you want. It's at the employer's discretion, right? So you can decide you're going to provide mandatory health benefits. You can decide you're going to provide short-term disability, long-term disability. You can provide sick leave as a bona fide benefit. And we'll talk a little bit more about how the new sick leave executive order kind of plays into this, but you can provide sick leave or extra vacation or any type of bona fide fringe benefit that is paid into a separate account that you can't yank back, right? So it can't be something that you can take back from employees. It's immediately vested in them once they work, so once they get those benefits. Where folks get into trouble there is, they'll say, I'm going to give employees this benefit of, I don't know, a country club membership. You can't do things like that. Again, these are usually benefit plans for sickness or wellness or those types of things. It's got to be communicated to people in writing, okay? So they have to know where that H&W money is going. You can also provide cash in lieu of this health and welfare money, or this health and welfare benefit. Keep in mind, if you pay it out in cash, it's considered wages to the employee. You have to keep them separate and apart from the regular wages, though, right? So on a pay stub, an employee should be seeing a slot for their wages, and they should also see a separate and distinct line dedicated to any health and welfare paid in cash. And the employee would pay taxes on it, you'd pay taxes on it. So it can be a more expensive thing to do, but it works really well with some populations of employees where their hourly wage rate is low. Keep in mind that you also may have obligations under the Affordable Care Act or something like that that may not give you as much flexibility to pay out in cash. And again, that's part of, you should talk to counsel about how that work. I have a question from someone that says, When changes occur to the wage determination, what's the timeline for incorporation into the contract? And that's an excellent question. We get this question all the time. So usually changes occur to the wage determination when the health and welfare rate goes up or when wage rates go up. And the Department of Labor changes those wage determinations. But a contracting officer has no obligation to incorporate that into your government contract until the option year or until they issue a solicitation. So, for example, health and welfare rates often are increased by the Department of Labor in the summer, so in June or July. Last year we saw no increase, but the year before we saw an increase from 402 to 427. We don't know what's going to happen this year, but all the wage determinations could change this summer. But your contracting officer has no obligation to incorporate that through a modification to your contract until your option year comes up. And at that point in time, they should be putting those things into your contract. You may see them. Some contracting officers, frankly, forget, and you may not see them. So if you really want your employees to get the benefit of those things, you may want to give your CO a friendly reminder. That kind of smooths things over. And then once a new wage determination is incorporated into your contract, you can request a price adjustment for any price impact it would have. And if you're curious about what you can include in those price adjustments, please let us know because it can be a somewhat complicated area of the law. And that goes to another question that was just asked. Is a contractor obligated to provide the benefits even if they're not incorporated into the contract until later? And that is not the case. Remember, this is a creature of contract. So if the H&W rate goes up, you wait until the new wage determination is incorporated into your contract before you apply it. Do not apply it early. And the reason why you don't want to apply it early, as I just mentioned, price adjustments. You cannot get a price adjustment if you give them the benefit before it's incorporated into your contract. So, for example, health and welfare rate goes up in June. Your option comes up in December. You decide to start paying employees a higher H&W rate in June. Well, the way that the price adjustment is done is the delta between what you're currently paying employees in December and what price impact that modification has. And if you take, let's just say the new H&W rate is $5 an hour, you're paying $5 an hour. At incorporation or modification, the H&W goes up to $5 an hour. $5 minus $5 is $0, right? So it is not great for employees. It really, really can hamstring you. So make sure that you understand when you can increase the rate. Generally speaking, contracting officers want to receive an equitable adjustment or a price adjustment. We like to call them price adjustments, not necessarily equitable adjustments because you're entitled to them. You'll want to do that within 30 days, generally, of receiving the modification. So let's talk about, I did receive a question before the webinar really even started about holidays, and I'm not really going to go over holidays a whole lot in this webinar, but I will answer the question. And the question that I received is, how can a company comply with SCA if there's a government holiday that the company currently doesn't observe? Should the company not work on that project on that particular holiday? It really depends on your contractual obligations. With respect to SCA holidays, you just have to provide the same number of holidays, not necessarily what's listed on that wage determination, but you have to communicate to employees which holidays you're going to recognize. So you could say the government's going to recognize, like the day after Christmas, and you know that, like they normally recognize an extra holiday or inauguration day or something like that. You could kind of shift around holidays, the 10 or 11 that are in your wage determination, in order to make sure that you're providing services to the government as you need to provide them. You don't have to provide additional holidays just because the government calls a holiday. Okay, so just because the government says, okay, we're going to recognize, July 18th as a holiday, you don't have to provide that holiday paid. They could use PTO or some other leave that they might have available for that day. but I do get that question often. Okay, let's talk about SCA vacation because we really want to dive deep and really understand vacation. This is complicated, so I'm going to do my best, but please, if I'm not clear, I encourage questions. The SCA vacation in its truest, purest form, in accordance with the regulations, is really a vesting system, okay? That means that an employee really has to work a full year before they get any vacation, before they're vested in any vacation. And I like to think of it like our 401ks, because a lot of us have had 401ks for a while. Maybe you're putting money into that 401k, but you don't get to take it with you until you hit a number of years of service with the company. And that's exactly how SCA vacation works, or is anticipated to work. The government wants to know that you're invested in their projects and what they're doing before the government is willing to pay, essentially, for vacation for non-exempt employees. So you really need to think about what the anniversary date of employment is. And we're going to talk about continuous service here in a minute, but just for a second, let's focus on employees that you're hiring, not employees that you're taking from a prior contract or predecessor contract. The day you hire them, the first day that they're working on a covered contract is considered the anniversary date going forward. That's the day that you guys got together in your relationship, right? So think about that as your anniversary of employment with that employee. And all that vacation, they're kind of getting it as they go along, but they don't get to use any vacation until they've put in a year of work. Okay, and on that anniversary date, they get their full allotment of vacation. I like to think of them as buckets that we're dumping into an account. So if I start work on July 1st of 2017, I have to work until basically the end of June, through the last day of June, in order for me to get my bucket of vacation on my anniversary date, July 1, 2018. Okay, but I get the whole thing at that point in time. And I get to use it, or I get to be paid out for it within the next year. So I vest in it on July 1, 2018. I can use it during that whole year of 2018. And then if I don't use it during that entire year, I have to be paid out for it before I get my next bucket on July 1st of 2019. Okay? I also included just an example of the types of vacation you're going to see in your wage determinations. They're different, so this isn't, my 1 week after 1 year, 2 weeks after 3 years, 3 weeks after 7 years. That's not representative of every wage determination, but it's an example of the type of what you're going to see on a wage determination. So what you need to be careful of, if you've had a policy in your employee handbook, for example, that has specific amounts of vacation that people get after certain years, you want to look at that and make sure there's an exception or a carve-out for your SCA folks that might get vacation at different levels, okay? If you have part-time employees, you're probably not going to know how much work that part-time employee is going to do during any given year. So the vesting system works really well for part-timers, because you wait until they've worked for you for a full year, you look back at how many hours they've worked in that year, and you prorate it, and you give them their dump of vacation accordingly. If you have independent contractors, you might want to just pay them in cash as soon as they vest it. You may not want to give them vacation because they're independent contractors. So you would just give them, say, a cash benefit as soon as they vested it. I have a couple of questions that came in, so I want to address them quickly. We're gonna address accrual in just a second, so just bear with me for a second. I want to go through the true SCA form first, and then we will definitely talk about accrual. So be patient. And then I have a question as to whether additional vacation can count towards benefits. And yes, it can. Remember, go back to our discussion of health and welfare benefits. If you provide vacation above and beyond the vacation that's required by the wage determination, you can count that as a bona fide benefit. You must pay employees out for their vacation, and we'll talk about that in a second. You can, technically, you are in violation of the SCA if you carry over hours and you don't cash them out. And we'll talk about that in just a second here. So let's go on to the next slide. Let's talk for a second about continuous service, because continuous service is really important. The last example we talked about, I hire an employee from day one, but the SCA recognizes continuous service, meaning that we're going to recognize all the years of service that an employee has put in on the same or similar contract with a predecessor or you, okay? So you might hire an employee that's worked for 5 different contractors over the years, but they're doing the same or similar work at a same or similar location, the same base, the same installation. And so all of their years of service get counted toward that, toward the amount of vacation they receive, right? So if you go back to the previous slide, I said you get, so much vacation after 7 years of service, or so much vacation out of 10 years of service. You're going to count all of their continuous service in deciding how much vacation they should really get. Their anniversary date is not the date that they were hired by you. Their anniversary date is the date they were hired by that first predecessor employer that they were hired by. And how do you get that information? Well, it's actually pretty challenging to get that information, because a lot of that information needs to come from the employees on an application. The contracting officer is supposed to help you get a list of those employees and their anniversary date, but we know that that doesn't always happen. And that's a challenge in bidding in contracts too. One question you might want to ask during the solicitation process is, can we get a list of service dates for those employees? Because that will really help us determine what our vacation liability is. Or can you tell us whether there are any, bands of people, just give us the bands of vacation so we can tell how much vacation liability we're going to have. But if you don't get that, you often estimate it, you average it over time and over the workforce, and you can come up with some amount to include in your bid. So when does a break-in service occur? A break-in service occurs when the break is intended to be permanent. It's not a temporary layoff, so we're not just stopping performance while we work out a protest and everybody's, going to come back on with the successor when that occurs. We're really talking about permanent breaks. We laid you off, and we didn't think we were ever going to hire you again. One example I recently ran into was that the government took certain positions in-house for a pretty short period of time. It was like 6 months. But so you have this predecessor working on this contract. The government takes these positions in-house, pays them as, essentially as GS employees. And then, 6 months to a year later decides, you know what, this really isn't our cup of tea. We're going to get a contractor on board to take this work over again. Well, that time they worked for the government actually broke their service date. And that's unfortunate, because those employees lost that time when they started working for the successor. But that would be an example of a break in service. Payout of vacation time. Again, it must be used or paid out by the next anniversary date, or when their employee gets their next bucket of leave. And the reason for this is that contractors, or that the government is concerned that contractors will get huge vacation liability amounts on their books. And because it has to be paid out at the contract end date, let's just say you have 50 or 100 or 200 or 500 employees, your contract ends, you have this huge vacation liability. They're concerned about non-payment of vacation or inability of contractors to pay. So they want to make sure that you're paying this stuff out year over year. So if you have a carryover policy, that would still be a technical violation. If DOL came in and investigated, they would make you pay out anything that's quote-unquote vested. You certainly cannot have a use or lose policy. Once they get it, they're going to be paid out at some point. They're going to be paid out at their next anniversary date, or they've got to be paid out at the end of the contract of anything vested, right? So if let's just say you have an employees that are working for you, your contract's coming to an end July 1st, you're going to look at anything that's been vested at that contract end date, and that's what you're going to have to pay out. the employee starts with the next contractor on, say July 2nd, okay, and that next contractor basically picks up, they don't take any of that vacation time over because you've paid anything vested out. But if employees have anniversary dates in August, September, October, that new contractor is responsible for giving them their dumps on their anniversary date with their first employer, right? So you could pick up a contract, July 2nd, and on July 10th have to give someone 4 weeks of vacation time, right? So that's why it's in a best case scenario, we have all of those anniversary dates planned out, or we know what they are before we even bid on the contract. Although, I think that's relatively rare. You also have to keep in mind that there's state laws. So California, for example, requires that you accrue vacation time. You actually cannot follow the SCA vacation rules, and you have to, in California, vacation is seen as wages that you earn as that time is worked, and so you can't do a vesting system like this. You have to accrue. So if you pick up contracts in California, you need to keep in mind that that you have to accrue it, and it has to be paid out even before the vesting date if somebody terminates before a year of employment or before their anniversary date. Okay. So let's talk about accrual for a minute, because I get this question all the time. Can we accrue? The answer is yes. You can accrue vacation time. There are some drawbacks of accruing vacation time because you're essentially advancing the vacation time. And if you're a company that's margins are thin, or you really need to make sure that you're controlling the amount of vacation time that's paid out, you may not want to accrue, because if you have them accrue that time, then and they take it, right, and then they quit 6 months in, you're out that amount of money. You're out that, that accrual amount, so to speak. A lot of states have rules that say once it's accrued, it must be paid out. Okay, so in those particular states, you can't have, once it's accrued, it has to be paid out. So if you're accruing it early, it's got to be paid out. In states where we don't have that issue, there are policies you can put in place so that employees can accrue time. They can even use time, but if they quit, you're not going to pay them out anything that's not vested. So you could kind of have a hybrid accrual system in those particular states. But again, you have to be looking at state law in the jurisdictions where you have employees to figure out whether you can do it, right? You are responsible for ensuring SCA compliance. So even if you accrue, you still have to be watching those anniversary dates. You still have to make sure that you're in technical compliance to make sure that you're paying out everything when it needs to be paid out. And that can be challenging in an accrual system, especially when the idea behind a lot of accrual systems is to put SCA folks on the same type of system as all of your other employees to reduce your administrative burden. But the reality is that you can't get out of this obligation to watch, those anniversary dates, to make sure that when vacation time is vested, it's paid out, to make sure that, the appropriate things are happening at the appropriate times. Okay. Again, there are different mitigation strategies depending on where your company is and what your company wants to do and how much administrative work that your company wants to take on. Okay, so you could have policies where essentially you treat this as advanced vacation, and you could have employees sign an agreement that says they have to pay it back if they don't, if they don't reach a year of employment. Again, we got to check state law, make sure that's acceptable policy in those states. But there are lots of different ways that you can do this, but you can accrue vacation time. You're just taking on an additional obligation that you might not otherwise have to take. And this slide just really emphasized state law vacation requirements, because we're seeing more, and we're going to talk about leave requirements in a second, but we're seeing more and more states take on vacation time, sick time, family leave. And a lot of times I get the question, well, I'm at a federal installation, or I'm at, you know, I'm based out of state X, or why would state law apply here? Well, the Supreme Court has basically said that when it comes to wage and hour laws, there is no conflict between the state law and the federal law requirements, and you have to comply with the most generous of those laws, okay? So it's really important that if you have, you know, a leave law in a state, for example, California, my California example, that provides more generous benefits. In other words, you know, vacation is vested as it accrues and as that employee works that time, then you have to provide the California benefit. So it's very possible that you might have a different system in California than you want to have in the other states. Depends, again, on what is important to your company. So I think I answered some of the questions. I'm getting lots of questions, and I think that's great. I'm really excited. I love it when I get questions. Sometimes it's crickets, so this is good. So one of the questions I think we answered, can we accrue when someone first starts working? Is that okay? Yes. Again, you could be taking on something that, an obligation that you don't necessarily need to take on, but there might be a lot of different reasons that it makes sense for your company to do that, including recruiting. If we use, I think I already answered. Sorry, give me a second while I'm just going through these questions. I want to make sure I keep up with them. If you take over a contract and someone's anniversary date is the next month, the previous employer has paid them out, so we only pay them for 1 month. Let's go back and think about that for a second. Remember, the previous employer only should be paying what's vested, not everything. And what the previous employer paid or didn't pay is not your responsibility. That's with the predecessor. So you need to be thinking about, what am I obligated to do as the successor? And what you're obligated to do when that employee hits that anniversary date the next month, they vest that full years of vacation into their bucket. So that's one of the challenges with accrual, too. Again, even if you decide to do an accrual system, you can do it. But if that employee hits their anniversary date the next month, you need to true up their vacation time to make sure they have enough vacation time to make up for anything they haven't yet accrued. Because they've only been working with you for a month, right? So they're only going to have accrued a month's worth of vacation, but on their anniversary date, they're due a year's worth of vacation, not 1 month's worth of vacation. So you need to make sure you true that up if you're using an accrual system. And that's really, really important. If a person quits or is fired with less than 1 year, do we pay the employee out? You don't necessarily have to, assuming state law doesn't require. So California would be the exception to that. Again, you want to make sure that if you're not using a vesting system, that you're using and using an accrual system, that you make sure your policy is clear that employees are not entitled to a payout of vacation unless they've vested in that vacation policy. You cannot have a use it or lose it policy for SCA vacation. It has to be paid out. That's why we use the term vested, okay? All right, let's move on. I promise I will get back to some of the remaining questions that I have not answered. I promise you. But I want to make sure that Megan doesn't kill me for taking all of her time. So, Megan, I'm going to turn it over to you.
Thank you. I'm going to talk about some of the state and local requirements, and then kind of at the end, we're going to work it all back to see how you should work in these state and local requirements while also keeping in mind federal requirements, including the SBA, but also including a federal executive order on sick leave. Next slide, please. Thank you. Because there really isn't a federal paid or sick leave policy in place that is applicable to pretty much all employees, we have seen a trend recently in the last few years where states and localities are kind of beginning to take it into their own hands. It can be statewide. We've also seen it countywide. So especially for federal contractors who are practicing in multiple localities, multiple states, you need to have an understanding of what is required in that particular state that you're performing the contract in. Some of those states recently we've seen are Washington, D.C., New York, New Jersey, and then Montgomery County in Maryland. For example, Washington, D.C. just passed their Universal Paid Leave Amendment Act. So this will grant all full and part-time private sector employees who spend more than 50% of his or her time working in D.C. with up to 8 weeks of paid leave for new parents, 6 weeks to care for a sick relative, and up to 2 weeks for a personal medical emergency. Now, this will be paid through an unemployment-type benefit. However, New York, on the other hand, also just passed, is set up to have the most comprehensive paid family leave program in the United States. It's going to allow up to 12 weeks of paid leave to care for a new child, a close relative with a serious health condition, or a family member who's called for active military service. This program is set to begin January 1st of 2018, but this one, unlike DC, will be funded by new employee payroll deductions. So it's important to keep in mind how all of these requirements, first, what the requirements are, and then how it's going to be paid. So you can factor that in as an employer for additional requirements that you have to meet along the way and see if there's additional funds that you have to money for, whether you're qualified or your employees will be covered under these plans. So that's definitely something to keep in mind. And other states that have currently a sicker family leave policy, in addition to DC, New York, and New Jersey, are California, Rhode Island, and Washington State.
And sorry to interject.
Go ahead.
I think a client brought to my attention yesterday, Arizona has one coming up July 1, just so that I get a West Coaster other than California in there.
So we are seeing a big trend in states and localities kind of just taking it into their own hands. And this can be extremely complicated and complex for employers who work across state lines and have multiple operations in different states. We're also seeing expanding reasons for why employees can use their sick leave. So, for example, the birth of a child, that now we're adding, adoption is being added. Particularly in Montgomery County, Maryland, and a few others, you can now use it if there's an instance of domestic violence, sexual assault, or stalking against the employee or the employee's immediate family member. So if your handbook currently states that your employees can use a paid leave policy for, let's just say, getting sick or having a child, but it doesn't say that it could use it for any instance of domestic violence or sexual assault, these items need to be added to your handbook. So if you have any concern regarding your handbook compliance with your state, with the state requirements that you operate in, we're happy to take a look. Some employers have various handbooks per state, and others have one general handbook that covers all the states that they practice in. And if you get a contract in another state that you've never worked in before, you may want to send us your handbook to see if that is still in compliance with the new requirements, with the new state.
Thanks, Megan. I wanted to talk really quickly about how these state laws might interact with your SCA requirements. So often there's this technical rule under the SCA that if there's a legal obligation to provide some other benefit, that you can't count that against your H&W benefit, right? So if you have a legal obligation, for example, in Hawaii, there's a Hawaii healthcare law that requires employers to provide certain healthcare benefits. So you'll see in wage determinations in Hawaii, the health and welfare rate is actually a lot lower if you provide that state insurance and you provide for medical care. The Department of Labor has not enforced that when it comes to state sick leave. I can't guarantee that they'll not enforce it in the future, but they haven't. So for years, we have been successful in developing paid leave policies so that you can double dip into the Sba Vacation and meet your state law requirements. There are some challenges in doing that because you still have to meet your sick leave requirements at each state level. So if there's carryover requirements in that state law, for example, then we have to account for that when SCA doesn't allow for carryover, right? So it is challenging, but with respect to these state laws, we have been able to do that. State laws tend to be a little bit more expansive than the SCA and what it requires, but we have been able to do that. You could also use the H&W to provide the sick leave required and count that against, for your state sick leave, you could use the H&W bank for that. So that's one strategy that we've used in the past. So let's go.
So next we're going to talk, go ahead.
Sorry.
We're going to kind of talk about the sick leave for government contract employees. So while there's no federal sick leave policy that would be applicable to all employees under any type of business, for employees that are working on government contracts, this would be applicable. So although there's no sick leave required under the SCA, Executive Order 13706, signed by President Obama, applies to contracts that are covered by the Service Contract Act. So although it's not required under the Service Contract Act, it's applicable to all requirements that have to meet the Service Contract Act requirements. Under the executive order, the employers are required to provide up to 7 days of paid sick leave annually. And this applies to all solicitations issued on or after January 1st of this year. So any solicitation going forward, this will be applicable to. As far as employees who are covered under it, it's any person who's performing on a contract covered by the executive order, whose wages are covered, as I mentioned, by the SCA, but also the DBA and the FLSA. If the contractor provides the employee of less than 7 days of sick leave, you have to provide your employees with the difference.
And I just am going to interject for a second. I don't know if we have it on this slide, but this applies to contracts issued on or after January 1st of this year. So you might have contracts that have been in place for a couple of years that do not have this incorporated yet. This will be incorporated over time into your contract, so you may not see it for a couple of years, but new solicitations issued on or after January 1st should have this in there, and we're starting to see a lot more of it. The other thing you should keep in mind is when we say those covered by the Fair Labor Standards Act, so you've got an SCA contract or a Davis-Bacon Act contract, and then you've got all those exempt employees we talked about that are not covered by the SCA or DBA, but as long as it's an SCA contract, those exempt employees also get swept up into this executive order. So you have to provide it to those exempt employees. With CBAs, there's an exemption under the rule that says if the CBA was negotiated before September 2016, you don't have to be compliant until 2020. But if you have unionized employees and you are negotiating after basically any time now, you should be incorporating the difference, any difference in sick leave, into those collective bargaining agreements. And that exemption expires in 2020. The idea is between 2016 and 2020, almost every CBA should be renegotiated with the new sick leave requirements. But if it's not, you're going to have to provide above and beyond what's in the CBA. The in connection with language really refers to employees that are not working directly. They're not a direct bill to an SCA or DBA contract, but they say work in the home office. They're overhead folks. Those people, if the general rule is 20% or more of their time is spent on a covered contract, you also have to provide those folks with sick leave. So this is really an attempt to get everybody as much as possible into this EO. We do not expect this to be revoked by the Trump administration. I get a lot of questions about that. When is this going away? But if any of you follow politics, Ivanka Trump is really on the family leave train right now. So I think there's this sense that that they are not going to revoke it, while at the same time asking Congress to pass a family leave policy. So I don't expect this to go away, although it wouldn't be the first time I'm wrong.
We also wanted to note that the requirement under the federal executive order is provided in addition to the vacation time that is provided through the health and welfare benefits under the SBA. So it's also, you have to keep this in mind as an extra level.
Exactly. So not only do you have to provide it above the vacation time, but if you're one of those companies that was using the H&W benefit to provide sick leave, this has to be in addition to H&W, in addition to vacation. So you'll have to give them even more than you already give them. Okay, let me advance your slide real quick. So I just wanted to include, Meghan alluded to this earlier, but I outlined here on this slide the reasons for sick leave, but it's a lot of what Meghan covered under the state sick leave. In fact, if you look at the Arizona sick leave law that's going into effect July 1st, it almost mirrors the federal reason. So a physical or mental illness, injury, medical condition, diagnosis, care, prevention, that's like going to the doctor, care for a family member, and then there's this whole category of domestic violence, sexual assault, stalking, counseling, if you have to go to court. All of these things would be covered by the new sick leave rule. And sorry, I advanced. I also wanted to make sure that you're aware of the documentation required by the sick leave executive order. It's fairly weighty. You have to inform employees in writing each pay period of how much sick leave they have. That would be like including their accrual on a pay stub. You have to have a record of approvals and denials of sick leave. So if employees submit sick leave forms or you respond to employees by email, you need to keep those. You can only request a doctor's note for absences of 3 days or more. So I see a lot of this in policies where it says we can ask you for a doctor's note anytime we want. Not under this executive order. Absences of 3 days or more only. And you may only ask questions about a reason for leave that's narrowly tailored so that you can establish benefit for that leave, right? So that you can establish the bare minimum that an employee is qualified to take the leave, but you can't start digging in. Employees have to give you notice of their request for leave 7 days in advance if they know, if the leave is foreseeable. But if they don't know, it just has to be reasonable amount of time.
Okay, so the amount of sick leave that has to be provided, as employees can accrue up to 1 hour of paid sick leave for every 30 hours worked on or in connection with a covered contract. So we discussed the covered contracts earlier, and employees who you are not required to keep records of, for example, exempt employees, you can assume just base it on a 40-hour work week, unless you keep records and it shows more or less. And you give it 7 days of paid sick leave at the beginning of each accrual year rather than based upon hours worked. So you get it on the anniversary that you're allowed to use up to those 7 days for that entire year going forward. At the end of period, as Nichole mentioned, it's included on your pay stub to see how much time you have accrued under the system and how much time has been used or how much time they have remaining. If you have an employee and then you fire them and then you rehire within the same 12 months, you have to reinstate their unused accrued sick leave. The reason for this is that employers don't avoid having to pay the sick leave by firing and then rehiring the same employees, which is why they have the 12-month time period. So it's more just a protection for the employees, not to have to worry about being fired to avoid receiving this benefit.
And an important note about accrual, you can cap accrual, and this goes into the next slide, but you can cap accrual at 56 hours a year. So that's that 7 days. So you have two choices. Give them 7 days at the outset of the year, let them use it, or let them accrue it at the rate of 1 hour for every 30 hours worked. And you can cap that at 56 hours. And the reason why you might want to cap it at 56 hours, and I'm going to go to the next slide, is because you have to allow carryover of any accrued time. So if you let them accrue more than 56 hours, then they can carry over more than 56 hours. But if you only let them accrue up to 56 hours and then they hit that ceiling, they can't accrue anymore. If they draw it down, they can accrue again. But if they haven't drawn it down, they can, you can just leave them at the ceiling of 56 hours. But if you allow them to accrue 70, 80, 90, 100 hours, you got to let them carry over. You have to let them carry over that amount. Megan, is there anything else you wanted to add on the slide?
Yeah, I mean, in addition, just to tack on to that, unlike the bank that you get under the service contract after vacation, you're not required to pay out any unused sick leave if the employee quits or is fired at the time of job separation. So it's important to keep in mind what benefits maybe you do have to cash out to the employees and do not have to at the end of their employment term.
So this might be one reason you want to think about, do I want to have a combined PTO policy or do I want to have separate banks? Because if you mush them all together, it gets really hard to show what you have to pay out and what you don't have to pay out. But if you can keep sick leave separate, it's a lot easier to show that, oh, I don't have to pay out this other benefit upon separation of employment. There are some other limitations that I think are important to note. You can't deny sick leave if someone's requesting sick leave for approved reasons. So even though this doesn't make sense, you can't say, well, I don't have anybody to cover your shift, so you can't take your daughter to their doctor's appointment, or whatever it is. You can ask that employees schedule things reasonably if it's foreseeable, but you've got to approve their leave. You have to allow them to use up to the accrued amount. So you can't say, well, I'll let you take 3 days off, but not the whole 7 that you've accrued. You have to respond promptly to requests. That means that if it's a foreseeable reason, you should get back to them fairly so they're not missing their whatever they need to take leave for. If you require documentation for an absence of 3 days or more, you have to give them about 30 days to provide documentation to you. But you can deny it. So if it wasn't for an approved reason or something went wrong or you saw on their Facebook page that they were sailing that day or something like that, you could deny the leave within 10 days of them giving you the documentation. You can contact health providers for verification that the doctor's note was real or what was sent in was real, but you can't ask the health provider other information. And you can take back any unverified leave. So if you found out a person was sailing for the day and you verified it, you can basically take back that leave from them. This is, and Megan touched on this a little bit, but again, you can't count this against SCA H&W benefits, unlike before with the state law requirements. This might impact SCA H&W rates in the future. The Department of Labor has said they are going to take sick leave law into account when factoring the H&W rate increases. This very well could impact how you look at your PTO policies and whether you can do it. A lot of contractors I know are starting to really think about how challenging it's going to be given the requirements of the sick leave executive order to comply with everything by doing a paid time off policy. So one thing you have to think about is, do you want to phase it in, right? So some employers have said, you know what, I don't care if all of my contracts are covered or not. I'm going to apply it across the board because I just can't deal with the administrative burden of phasing it in contract by contract. Other contractors are saying, you know what, I'm going to break out each class of employee by contract and I'm going to phase in and I'm going to have a policy that's different for every single group of contract employees because that makes sense for me. You might want to have some sort of uniform policy strategy, right? So how am I going to handle this? Am I going to segregate exempt employees from non-exempt employees? And there might be really good reasons, really good cost-saving measures to think about segregating sick from vacation. Think about how we're using H&W. Do I want to provide even more sick leave, right? Keep in mind that if you are going to provide sick leave as an H&W benefit, it is vested, meaning any sick leave that's provided as an H&W benefit, even if it's above and beyond the executive order benefit, that has to be paid out to employees, unlike the sick leave under the executive order. So you still might want to keep those in separate buckets or separate accruals so that you can be clear if you're ever audited. I think we are basically out of time. It's 2:59, and I have so many great questions, but I promise you I'm going to look through them really quickly. but I think most of them I will email you individually to answer the question. And if you're interested, I also have somebody that I think very fondly of, and she said, don't forget about the quirkiness of the states of Washington and Oregon. And I completely agree. I was just out in Washington State, and I will email you because I'm going to be there soon and would love to see you. You know who you are. But thank you so much for attending our webinar today. We really, really enjoyed doing these. If you enjoyed the webinar, please give us feedback on what types of webinars we can provide in the future. Thank you so much and have a great afternoon.
Thank you.